Good evening, everyone. Today, we'll look at the quick revision series on various subjects. And today, we are starting with public international law. So, as the public international law comes about, we think, okay, why it is has become very important at the present context. So, I'll tell you, in the contemporary situation, how the various wars are happening. Like it could be various examples. It could be Iran and US conflict. Then there could be a conflict of Strait of Hormuz. Then there is Russia-Ukraine crisis, and then there is the Israel crisis or the Israel wars going with the Palestinian crisis. Now we go about and read and understand that okay, what do we need to understand about public international law? What do we need to learn about it? What do we need to read about it? And what are the concepts that we'll have to study about when we come to the topic public international law? See, when public international law comes about, there are various definitions, right? That the if we go about like the first definition or like the traditional definition, we come about with the Oppenheim's definition. Oppenheim said that the body of customary and conventional rules which are considered legally binding by civilized states in their intercourse with each other. Now understand, he said civilized states, right? So in Oppenheim's definition, we are able to comprehend that yes, only the states, as in between two states or like between the interaction of states, the body of customary and conventional rules will come into play. Now, this had a basic fallacy or this had a basic criticism. For example, if we go about UN reparation case in which a diplomat or an envoy of UN was killed in when he came to mediate in the Israel crisis around uh, prior 1950, then we can see that there the envoy was killed and the envoy was representative of UN, and UN is an international organization, right? So as a state, we cannot apply this traditional definition on that. So we kind of understand that yes, in the present context, we cannot apply the Oppenheim's definition on that. Why? Because simple. The states, it talks about only between the interaction of states. I'll repeat it again, considered legally binding by civilized states in their intercourse with each other. Then comes the savior, the J.G. Stark's modern definition. What modern definition gave is that it was the same, including rules and all of those things, but it said governing international organizations, individuals, and non state entities. Correct? So, this definition became more like, exhaustive. It included more entities and more subjects onto which the international law can apply. Correct? So these, when we go about the definitions of international law, we need to understand about this, correct? Now, nature of international law, that whether international law is it a true law or not. So we know, understand, right? When we look at about the law, they are basically three things which has to be present. First, the legislature, correct? The legislature or the governing body, then the enforcement, correct? And then the sanction. When we talk about any law, these three things has to be present. In the international law, like when we go about it, we understand that these three things are absent. That's what Austin said. This is also called the negative view or the skeptic's view. What Austin said was, or what also subscribed by Hobbes and Holland was, that law is a command of sovereign backed by sanctions. Correct? That we know about Austin, that yes, that's what he said. But it said international law has no sovereign legislature or sanction, which he pointed it out. And he also said that it is international law is merely a positive international morality. But in practice, does it actually happen? No, because state themselves, international law is something which state consent to it and state feel obligated to follow it. That's where the positive view comes about. The Henkin says, and all, Henry Main also subscribed to this definition, that almost all nations observe almost all principle of international law almost all of the time. States do not deny international law's existence. What basically they said was that international law is something which is based on states' consent and states themselves feel obligated to follow it. It is also governed by a principle called pacta sunt servanda. a very important principle elucidated in Article 26 of ICJ statute, which says that it is a supreme norm which under which the state themselves should feel obligated to follow it. Pacta sunt servanda means basically a treaty should be applied, a treaty should not be broken, a state cannot go against a treaty. Now, when we say a state cannot go against a treaty, it means when the state is a party to that treaty. When a state becomes a party to the treaty means that the state is also a signatory and has also ratified the treaty. Correct? Now we go ahead about the theories on basis of international law. The first one being natural law theory, which says that international law is a part of law of nature, which is basically a traditional viewpoint which Grotius and Vettel all came about. Then there is a positivism theory, which says international law derives validity from state consent, and hence, as I was talking about pacta sunt servanda, here pacta sunt servanda will apply. Correct? Now, when we go ahead, Hugo Grotius, we cannot ignore this guy when we are reading international law, because Hugo Grotius is called the father of international law. Hugo Grotius wrote a book, and in which two very important uh, concepts he gave. He gave about the concept of jus in bellum and jus in bello. I'll repeat again. He gave the concepts of jus ad bellum and jus in bello. Basically, these two concepts became the cornerstone of various laws. The first one being humanitarian law, and then the war, like how do you do the war, the art of like the self defense clause, and also the humanitarian aspects of law, that no civilians should be, subjected to war, and all the injured should have been given opportunity to take the medical care, like going ahead with the war in or during the period of war. These two principles form the cornerstone what Hugo Grotius in his book De Jure Belli es Passes. This book became so important, and these two principles became the cornerstone of international law. Right? Now we go ahead to the sources of international law. Now sources of international law becomes the most important part of international law, because you have to understand that okay, we are studying that international law is something that states should feel obligated and all of those things. But then where is the source? Where is the law actually coming from? This is where sources of international law, Article 38, Clause 1 ICJ statute tells us. What does it actually mean? It says that there are four sources on which we can look for the sources of international law, right? It's a rapid revision series, so we'll go fast about each of them. But yes, the first one is international conventions and treaties. This become a very primary source, right? What is actually it is? It's basically the treaty. Treaty can be of two forms: bilateral and multilateral. That is a treaty between two states, that is become bilateral, and treaty between many states, that becomes multilateral. So this is where international conventions and treaties becomes important. It becomes a primary source, and the treaties, these law making treaties create general rules. Examples could be UN Charter, Geneva Conventions, and so on. Correct? However, treaty contracts are binding only on parties to that treaty. That we can understand, yes, because these are the lawmaking treaties, these are the treaty contracts. The second one being international custom. Sir, custom always, agar like if we are reading about international custom, you should be very well aware about the North Sea Atlantic Shelf case, in which it was said that any custom has to have like two important elements. The first one being state practice, the second one being opinio juris. What these are actually, state practice is consistent general conduct. It means that something which has been followed by the states during a long course of time, correct? But the second one becomes more important, opinio juris, which is said that is it is a belief that practice is legally obligatory, that states themselves feel that it is their obligation, that the custom has become so important that the states feel themselves obligated to follow that. Correct? The case is North Sea Atlantic continental shelf case. Correct? Now, onto the treaties also, if I may refer to a case, you may look at SS Wimbledon case. Now, the third one being general principle of law. The principles common to major legal systems. When we look about the systems, we know that there are various doctrines, various laws, or which aren't even codified, but they are the legal principle which will apply to common masses. This includes good faith, res judicata, unjust enrichment, and estoppel. These principles will apply no matter if they are codified or not, whether they are present as a treaty or not, but they will apply in general parlance of law. The fourth one becomes judicial decisions and writings of publicists. These, like the last fourth point, becomes the subsidiary means or the subsidiary source of law. When we read about Article 38 Clause 1, these include the writing of publicists, which comes into juristic decisions, and judicial decisions. Now, one question can come into your minds: why ICJ decisions are like here mentioned, like as a judicial decisions, but they aren't as important? For a simple reason that the doctrine of stare decisis that we read about the various judgments and the operation of judgment, we read that stare decisis does not apply to ICJ decisions. That means ICJ decisions are not binding subsequently on other decisions. They just hold a persuasive value and not a binding value. It is also given in Article 59 of ICJ statute that the ICJ judgments have no stare decisis. Correct? Now we go ahead and see that municipal laws versus international law. See, there can be two types of countries. One can be the country which follow the monism, and one country can follow dualism. What exactly is this? Dualism is a country that where when they sign a treaty, right, they take it as a separate distinct system. That law, that even if it's a lawmaking treaty, that will enter into their law when it is incorporated by a domestic law or a municipal law. Correct? So dualist country, what they do is there is a two separate distinct system. International law cannot operate directly unless it is incorporated by legislation. Unless it is incorporated by legislation means that they have made a domestic law onto the base of that treaty and then they incorporated it. Where monism countries, there is only one system, and international law they call it superior, and domestic jurisdiction delegate from international law, as in the international law directly applies on their domestic or the municipal law system and sometimes even take precedence over the domestic laws. For example, if I may say GDPR, GDPR by EU is directly by the monist country. If there's a monist country, such as any country in European Union, suppose, for example, any country in European Union will apply GDPR directly into their municipal law. However, when India took the principles of GDPR, they went through the incorporation and formation of a domestic act or a municipal act called DPDP Act, and then it came into their system. So, very simple, dualism, two separate distinct systems. International law is different and domestic law is different. Monism, they overlap and they are taken as together as one system. Correct? What is delegation theory? Delegation theory is nothing but the operation of dualism, where under international law it delegates to each state's constitution to the right to determine how treaties come into force. Basically, by delegation, they go into the transformation of that international treaty into the municipal law. Correct? Now comes the subjects of international law. On to what people will apply international law. Did you remember that when we were starting the revision series, I told you about the two definition of Oppenheim and J.G. Stark. So in Oppenheim definition, we understood that yes, it does only apply to the states, and like according to Oppenheim. But then we understood that okay, by UN reparation case, we understood that an international organization may also come into the purview of the same. And hence what we did was applied J.G. Stark definition, onto which it was included that it can apply on individuals, international organizations, also non-state entities. That's what the subjects of international law is. Correct? They say it can be on states, international organizations, and all subjects. Like for example, reparation for injuries case. Correct? Now, when we go about states as a subject, we also go about the essential element of state. That what are the elements that a state should constitute before it can be called a state. So we go and take the principles from Montevideo Convention 1933. It basically tells us the four important components. The first one being permanent population, the second one being defined territory, the third, defined territory means the fixed portion of earth, both land and territorial sea. Don't get confused, is just the land boundary. But it also includes the territorial sea until the limit of 12 nautical mile. UN clause give other zones too, but for territorial context, for the defined territory, we take is we take as 12 nautical mile as the defined territory, and also the airspace, continental shelf, etc. The third one being effective government means any form capable of controlling territory and fulfilling international law obligations. Correct? The fourth one is sovereignty, and it is the most essential element. It means that the state should have sovereign power over the subjects, over the state's subject. Sovereign power can be in two forms, internal sovereignty and external sovereignty. Internal sovereignty means that it has the supreme authority within its territory. It only can make laws for its subjects, for its citizens, and so on. External sovereignty means independence. What actually it means is external sovereignty means suppose if any state, international negotiations and all the decisions are taken by a different state, then then it does not have external sovereignty. That's the whole point of it. That under sovereignty, both internal sovereignty and external sovereignty should exist. Then only it would be called that yes, this state has sovereignty. If a state has all these 4 points, then under Montevideo Convention, it can be called that yes, it is a state. Now we go to the kinds of state. First, see, federal states we know about, we have studied about the federation states, so it will be USA and India. So from a higher authority to a lower authority. Confederations, that is weak central executive, correct? Confederation means that there is not a very important or very powerful central executive upfront. Protectorates means half sovereign. For example, before 2007, all the international negotiations for Bhutan prior 2007, India used to do it. In onto the matter of fact that yes, in Bhutan is a small country and India needs to help it, for the things like that. So it was a protectorate state until 2007. Then there is a neutralized states, mean the states which have taken the ultimate decision to not to go in war in any situation. The example is Switzerland. Switzerland doesn't go into war. The last one being condominium. Condominium means that there are various, some example can be lake or some part of a territory where there is joint administration. Like for example, Lake Constance. Joint administration means that suppose Lake Constance takes the territory of 3 separate nations, correct? All these 3 states will exercise the jurisdiction over it. Now, this was the kind of state. Now we come to the recognition of states. Recognition of states, the first one being constitutive theory. What is constitutive theory exactly is that it is like when the internationally the other states will recognize that state, then only it will be recognized. That state will be recognized as a state under constitutive theory. I'll repeat again. When all the other states in the international community will recognize, it says also recognition creates international personality. Then rights arise only after recognition. Correct? That is constitutive theory. Now there was a criticism for this, that how many states are you talking about? How many states we have to look for the recognition before we call any state as a state? Then comes the declaratory theory by Hall, Montevideo, Article 3. Okay? Recognition is merely an acknowledgement. It means that if under Montevideo Conference it has achieved all the 4 elements that we studied, it will automatically be recognized. The other state's recognition is only acknowledgement. It can be still called as a state. Correct? Now at the last it comes under de facto versus de jure recognition. We need to understand it because de facto and de jure is simple. De facto is by fact, de jure is by law recognition. What exactly it means is de facto means provisional. like for some time, and de facto recognition is revocable. Remember this always. De facto recognition is revocable and gives limited rights. However, de jure recognition is full, permanent, and non-revocable. It is non-revocable. Correct? Now we go ahead and let's see about modes of acquiring and losing territory. See, it's very simple. We'll look at the modes of acquiring territory, and onto the same we can look at the modes of losing territory. The first one is occupation, appropriation of terra nullius, effective control. Correct? It means that any land for which nobody was there, and the state came first, and terra nullius means like the state had no other occupier, or like the owner or the control of any state before. The state went and it went into occupation. The second thing is prescription. Prescription is continuous and peaceful possession, and usually it is more than 20 years. What is peaceful possession? Peaceful possession means that no other state has objected towards their occupation on that land or that territory. Correct? The third one is accretion, that is natural or artificial condition by some natural causes. The territory becomes bigger. In coastal states, we can see that on all of those things. The next one is cession. It is the voluntary transfer from one state to another. Correct? The second last one is annexation. Again, military acquisition, very simple. Then again, when we look at this annexation, remember always UN Charter Article 2 Clause 4. It's very pertinent and it's very important when we look about the annexation. Then we go about to the adjudication, that is assignment by conference. That okay, that some adjudicating authority adjudicated that yes, this territory should go to this state. Losing territory again, say by session. Okay, see, one state by voluntary transfer, one state will take it. The state which will be losing it will also be a session. Then operation of nature, again like the accretion, operation of nature. Then there is subjugation, revolt, renunciation, and granting independence of a colony. These are the modes by which a state can lose territory. Then comes, now it's a very important part, the state jurisdiction. That yes, a state can apply jurisdiction over its territory and all of those things, but can it also go beyond the territory? Let's look at that. When we look at the principle of jurisdiction, the first one is territorial principle. Territorial principle is what we all know, that it is the primary jurisdiction of a state over all the events happening on it. See, it's the absolute use of a sovereign power. So if any activity over any event on its territory, then it can use the territorial principle. Correct? The second one is nationality principle. Don't get confused about any other thing. I'll make you understand one by one. Okay. The second one is nationality principle. Nationality principle says that jurisdiction over nationals for acts anywhere. My national, my citizen went to a different state and committed an act there. I still have the jurisdiction over that person under the nationality principle. Correct? The third one is protective principle. Protective principle means that jurisdiction over aliens matlab, like here, that person is not even a national of that state and whose acts are prejudicial to state security. What basically it means is protective principle, that the act hasn't even happened on my territory and that person is not even my national. See, if it happened on my territory, it would have been a territorial principle applied. Simple. The second one, if it was my nationality principle, I would have applied, the state would have applied, and simple. But the third one says protective principle, where the consequences are coming to your state even though the act did not happen on your territory or the person is not your national. For example, a person is sitting on a different state and is committing an act of a cyber warfare, or is sending a consignment of drug to my country. He is not here, correct? There's no territorial principle here. Also is not my national, so I cannot apply also the nationality principle. Hence the protective principle comes into play, which says that jurisdiction over aliens mean not my national and whose acts are prejudicial to state security. meaning that the consequences of that act are felt in my state. Then that's why it comes the protective principle. And at the last, it would come universality principle. Basically, these three principles are the most important. Universality principle is jurisdiction over crimes committed by anyone everywhere, piracy, war crimes, and crimes against humanity, hijacking, terrorism, etc. Correct? Now we go ahead and look at what else we need to understand about it. Okay, now we understand that yes, these are the principles of jurisdiction, but under what circumstances there can be any immunity about it too. So that is called sovereign immunity and diplomatic immunity. See, international law puts all the states as equals, as sovereign equals. That is why sovereign immunity, that per in param non habet jurisdictionem, that equal persons cannot be sued in each other's court because they are sovereign equals. Correct? Now, diplomatic immunity comes from or takes the forms from the VCDR 1961, Vienna Convention on Diplomatic Relations 1961. It says it has two very important articles, Article 22 and Article 29. Article 22 says that the mission premises or the embassy shall be inviolable. And for diplomats, it says Article 21, Article 29, diplomatic agents person is inviolable means no arrest or detention. One thing that you have to keep in mind is that they are immune, absolutely immune from criminal jurisdiction. However, they are limited civil immunity. There are exceptions to civil immunity, okay? Now, there's also a condition that immunity is also waivable by sending state. If I have sent my diplomat to another country, I can waive off their immunity. Now, for that, Tehran hostage case becomes a very prime and very important example when you are studying about the immunities, about the VCDR and so. So in that, Iran violated VCDR by failing to prevent the seizure of US embassy. When you'll understand or when you read about the case, you'll get to know about the facts that Iranian armed students stormed inside the embassy. Now, Iran said that they were students, they are not my someone who can be, my military or something, that the state has done the act. These are Iranian students. But US said that Iran had violated VCDR by failing to prevent seizure of US embassies. Correct? Now, at the last, there is also consular immunity, which comes from VCCR, that is Vienna Convention on Consular Relation 1963. It is basically a lower level of immunity as compared to VCDR, correct? And it is only for official acts. For that, please read Princess Zizinyov versus Khan and Bigelov, 1928 case. This is also a very interesting case. This is a funny case, and read about it. Now, revising further, we go to the Law of the Seas, UN Clause 1982, United Nations Convention on Law of Seas 1982. UN Clause 1982 becomes the constitution for Law of the Seas. That is, that it basically makes the zones, correct? First one is internal waters, that is landward side of baselines, no right of innocent passage. We'll understand what is innocent passage is. And full coastal state jurisdiction. Basically, simply, the internal waters inside the state's territory, that would be basically internal water, simple. The second one being is territorial sea. Suppose it's a state, so 12, this is sea suppose, so 12 nautical mile would be the distance until which it will exercise full sovereignty, including airspace, seabed and so. But here, right of innocent passage shall be given for foreign ships. That is, that if any ship is not detrimental to your state's interest or your security or something like that, then in that case, you have to give the right of innocent passage to that ship. It also gives a clause that submarines, if they are in the territorial waters, they must navigate on the surface. And it's the case of Corfu Channel case. It's a very relevant case for the same. You might read it. Okay. Then it is the next after. So this is the territorial water, correct? The territorial sea. After that, there is a contiguous zone. Contiguous zone go about 24 nautical mile. Basically, this gives the control for customs, fiscal, immigration, and sanitary regulation. So, if for stopping customs, as in smuggling, for fiscal, or even for the immigration, you can exercise jurisdiction under the 24 nautical mile. After that, it's mostly the economic benefits extended under the UN clause. The second one being the EEZ up to 200 nautical miles. After that, until 200 nautical miles, it is basically EEZ. What EEZ basically is, it's exclusive economic zone. It is the sovereign rights over the living, non-living resources. Correct? Now, after that, like after the EEZ, then comes the continental shelf and high seas. Correct? Until 350 nautical miles, the continental shelf is there, which gives the exclusive rights over the seabed resources. And after that, it's high seas, open for all. Now comes state responsibility. Okay, very pertinent and very important act. When will be the state responsible for any act done? Or if I may say, suppose something wrongful has happened and a state reaches to the ICJ for the any relief for the same. How will that state be held responsible for anything done? For that, we have to see two things. Remember, the first one being the act, second one is omission. First one is act, the second one is omission. See, for the act or omission, both the two things should be attributable to the state. Attributable to the state means that we have to prove that yes, the state has done it. For the attributability of the states, we can see that the acts of state organs, that is police, army, or the person exercising governmental authority, or the private individuals on state instructions, all these people will come under the act. And if anything has happened which the state has prevented, or which the state has actually failed to prevent it, that will come under the omission. Remember, we were reading about the Iran-Tehran case, and we read about how Iran failed and violated Article 22 of VCDR. That's what the omission is. For state responsibility, attributability can be done by both. First, we have to check the act, or if the omission was there, that the state did not do due diligence. For that, Corfu Channel case can also be seen, that how even the omission can be held as a state responsibility. Correct? Now, reparation. Sir, remedies. What are the remedies for that? What are the remedies a state will basically seek? There are three things. That the first one is restitution, compensation, or satisfaction. Restitution is basically to restore something. Compensation is basically to compensate for all the damages done. And satisfaction is something, any act which the other state which is seeking the relief feel that yes, it is satisfactory in my books, and hence I'll take that reparation or the relief as given. If we go ahead revising the concepts further, it is nationality and statelessness. See, nationality is legal bond between the individuals and state establishing mutual rights and duties. It is basically, nationality is basically the link between the state and its subjects or the individual. The mode of, so basically traditional way of establishing it was jus soli and jus sanguinis. Jus soli means based on birth, jus sanguinis means based on descent. Based on descent means actually based on blood. So jus soli means based on birth. Like if an individual is born in that state, under jus soli it will be given citizenship. Under jus sanguinis, if their parents or forefathers were from that state, it will be given citizenship. But the new modes for acquiring nationality, this is not the exhaustive list. It can include birth, naturalization. Naturalization means marriage, legitimization, option, domicile. Then there is resumption, subjugation, cession, option, registration. These are all the modes for acquiring nationality. Now there is a very interesting case, Nottebohm case. Please do read about it, that how Guatemala was seizing the properties of a national who had the origins of German, but he went into and took the nationality of Liechtenstein, and then said, hey, I am a national of Liechtenstein, how can you seize my property? ICJ said there should be a genuine link to the nationality. The genuine link, nationality must reflect a genuine or effective connection. That genuine link can only be said when looking at the nationality of that person. Statelessness means that when there becomes a condition, suppose there is a conflict of just Sally and just Sanjunis, and a person cannot claim a nationality between both the countries, then it becomes a condition of statelessness. Now we come to the concepts of extradition and asylum. See, onto the extradition, whenever we look at the extradition, we all know a brief idea about the extradition. We have read about it, that the process whereby one state surrenders any individual to another person, an accused convicted of a criminal offense. But when can extradition happens? Remember, it can only happen when there is a treaty existing, then the basically treaty existing or under reciprocity. The second one being double criminality. That is, it has to be a crime in one state where the crime has been committed, and also in the state from where the requesting state is asking, please give us that individual. There should be double criminality. Then there should be a speciality. Speciality means that for the offense you have extradited that individual, only for that offense the trial can happen. The next one is political offense exception. For political offense, you cannot extradite another person. Correct? Then there is nationality exception. Basically, if that individual has done a crime and went to another state of which he is a national, then there that country might prosecute that national applying the nationality principle that we have studied, and hence extradition will not happen. Correct? Also, there is non-extradition for capital punishment. If a country feels that if we extradite that person back to the state where the offense has been committed, there is a chance of capital punishment, the state will not send it back. It's called the principle of non-refoulement. It's a very important principle, non-refoulement principle. Then, do you remember we just studied that political offense are an exception under extradition? Now, for territorial asylum, understand, every state exercises sovereignty, and under sovereignty, it can grant asylum. Correct? These are basically done for the political offense. Correct? We all know there are various examples we have studied over the years, that what are the examples of territorial asylum. The Dalai Lama case coming to India can be one, and so on. Correct? Diplomatic extraterritorial asylum. Usually, international law does not recognize on extraterritorial asylum. What I mean is, in Colombia versus Peru, one individual did any political offense and then went ahead and went inside the Colombian embassy. And Colombian embassy said that yes, we are a sovereign country, we are giving an asylum. Now that embassy was situated in Peru only. So this is basically an extraterritorial asylum. International law says it can only be recognized if there is a customary law present for it. In normal circumstances, we would not take it. Now we come to the VCLT. VCLT, I told you about the Pacta Sunt Servanda, Article 26 becomes the cornerstone of all the treaty laws. And then there are the stages of formation for treaty. Accreditation of representative, then there is a negotiation on the table, then there is a signature. After the signature, the state shall ratify it. Then there is accession. Accession means any party which has not been a party to that treaty, it can later come into and become a party to that treaty. Then entry into force, there is a date given, onto that date it comes into force. And then there is a registration, that is Article 102 UN Charter says that unregistered treaty cannot be invoked before UN organs. So registration means like the UN will publish and all of those things, UN or any lawmaking treaty organization, whichever it is. And then the last, incorporation into state law. For dualism countries, they will, after the ratification, they will incorporate into their municipal laws, and that's what it is. Then there is a reservation and invalidity and termination. Remember, invalidity, error of fact, fraud, coercion, violation of just cogence. Just cogence means any principle which is so important that you cannot make treaty against it. Basically, suppose we make us two states come together and form a treaty for genocide. That treaty will be against the principle of just cogence. Hence, these treaty won't come into play. Then we come into the United Nations organs. There are various purposes and principles. There are various articles, or like we have to remember the one being the non-intervention in domestic affairs, Article 2, Clause 7. Then I also told you about Article 2, Clause 4. Then about the Security Council, about the General Assembly. This you will have to study. Then these are the key case laws. When we are studying about international law, these are the cases you have to basically remember. You have to understand what legal principles they were applied on. The first one is the SS Wimbledon case, in which I told you about that the treaty may override customs. In like if they are conflicting, treaty will override custom. Remember I told you about the sources of international law. They are in their order of importance. Like first will be treaty, second will be custom, then will come into general principle of law, and the last would be subsidiary means. Then there is a Paquet Habana case. Thus, custom is part of domestic law. That in domestic law, customary international law can be incorporated directly. UK basically imports all the customary international law into the domestic law. Then there is a reparation of injury. I told you about the UN envoy who got killed. Then there is the Alabama claims case, which is the landmark case for arbitration precedent. Which is this case can be which this case can be seen as the first case where the arbitration started happening. Then in the state's jurisdiction and see, there is the Lotus case, in which it is said that the states are free to exercise jurisdiction unless international law prohibits. So basically Lotus case happened in high seas, and the ICJ said that yes, you can apply jurisdiction unless and until there are any other treaty or any custom which is prohibiting you to exercise it. Then there is a Corfu Channel case. I was telling about the state responsibility for knowledge of harm. Agar due diligence, like if there is an absence of due diligence by the state, it will come under the omission, and hence the state will be responsible. Then I told you about Nottebohm case, that effective nationality is required. Effective nationality will be seen by the genuine link between the nation individual and the state. Then there I Malone case, hot pursuit case. Basically, you can chase someone for a continuous chase. That jurisdiction will also apply over and above the territorial water, but it should be a continuous chase. However, the action should be proportionate. Here they sank the ship, and it was said that intentional sinking of that ship was illegal. Then the Tehran hostages case, I told you about the BCDR obligations were violated in this. And then there's individuals and organization, Barcelona traction case, in which it was said that erga omnes obligations are owed to the international community, not just between the states, but to the all of the states. Then there's Nicaragua versus USA, where it was said that customary international law on use of force operates parallel to UN Charter. So if there's UN Charter article prohibiting it, and there's international customary law is also prohibiting it, they will both be applied parallelly. And there's a Colombian Peruvian asylum case, that I was telling you about, the Peru Colombia case, which was basically granting state cannot unilaterally qualify offense as political. And it has to be said that even if you are claiming international customary law, it is to be subscribed by both. Subscribed as in it is to be believed as an obligation by both the states. By this, we come to the end of the rapid revision or the fast revision of the international law. This quick revision, I am sure, would help you for understanding that what are the concepts that we need to learn, and all of the important things that we need to remember when reading international law, and what are the possible cases that can come into, and so on and so forth. So I'll leave it to you at this. For CLAT UG and CLAT PG preparation, you can always reach out. CLAT Possible will are always there to help you all. Until then, keep reading, keep learning. खत्म हो गई है